Good evening, everybody, and welcome to our Strata Committee training this sunny December afternoon. Thank you so much for your support in supporting this initiative of having regular Strata Committee training seminars. Feel free to use the Q&A function or the chat function in Zoom if you'd like to ask any questions. We'll endeavour to get to as many questions as we can during the session. And just FYI, this session is being recorded. And recordings will be issued to any Strata Committee members that were unable to make it, as well as yourselves who have obviously been able to log on tonight. Just to introduce who we are. So my name is Andrew Tunks. I'm the Learning and Development Director here. You've probably seen my mug on previous Strata Committee training or owner webinars. I'm kindly joined by Jessica Zanich tonight. She's our Learning and Development and Strata Manager Extraordinaire, who's decided to give up her evening and co-chair this webinar with me. Thank you, Jess, for logging on tonight.
You're welcome, Andrew. I'm glad to be here.
No worries. Just a little disclaimer before we get cracking with the content. This webinar is for informational purposes only and should not be constituted or construed rather as legal advice. So this information provided in this webinar is not a substitute for professional legal advice. So if you are struggling with an issue at your Strata scheme and want particular legal advice, reach out to your Strata manager, who is obviously able to direct you to the appropriate legal representation. Also, just to kick it off, to just explain what our training, what training our Strata managers regularly receive. So on the screen here is a whole bunch of different courses and statutory and voluntary training that we do here at NetStrata. We have drafted a lot of content ourselves. So up on the screen there is a whole series of different training books, guides, and courses that we've drafted for our team. So our team are Strata experts, as well as they are proficient in many other things like fire systems, electrical apparatus, plumbing and roofing, building defects, etc. Now, they're not engineers or plumbers or electricians, etc., but we do make sure that our Strata managing agents do have a sound knowledge of Strata, basically, and everything therein. Strata committee training. So we do also obviously offer this on a quarterly basis, as you're well aware, because you're logged on tonight or you're watching this webinar. But an initiative in 2024 and 2023 was to commence quarterly Strata committee training webinars. Now, the state government, I believe, is looking at making this mandatory next year in 2025 for Strata committee members. So you're well and truly ahead of most other Strata committee members by attending these webinars and having a listen. If you've missed out on any training webinars, feel free to click on the links that would be in the body of the email that you would have received to attend this particular webinar and any other previous webinar. So all the topics are listed there. Just click on the link. It'll take you to the YouTube recording and feel free to share that with anyone in your Strata committee if they have unfortunately missed tonight. There might be something that we talk about that you think might be relevant for some of your committee members or owners in your scheme. Feel free to forward the link and they can click on that and have a listen. All right, a little bit about who we are if you're not too familiar with it. So NetStrata were established in 1996 in Hurstville, Carlton. We opened our Wollongong office in 2011 and we're very proud to have received numerous awards, Large Business of the Year 2019, 20, 21, 22, 23, etc. And there's some little happy snaps of us on the screen there. What have we been working on? Well, one major item within NetStrata is our software team and our software development. We've been busily putting together our Strata management proprietary software as well as our owner app. So if you don't have our owner app, I will flash up a QR code at the end of this webinar where you can scan the screen and download the app. Our NetStrata or Strata Space app now has the ability for lot owners to look up their levies and download their ledgers, which previously they would have had to log on to a portal or email their Strata manager. You can actually now get that straight from your app. So nice and convenient. We've also been onboarding a whole bunch of new trainee Strata managers and bringing a whole bunch of trained, seasoned professionals into our business. So we do specialise in traineeships and we also have a number of experienced managers from other companies that have joined us of late. We also do site inspections if you're unaware. So we're always at our client schemes having a look at making sure that cleaning is done correctly, looking at, completion of works and jobs and meeting our strata committees, etc. So if you haven't received a copy of an inspection report for your building, you can no doubt reach out to your strata manager and grab a copy of the most recent inspection report. They will also be available on the app in the coming months. A big focus on training here at NetStrata. So there's a little happy snap on the right-hand side of the screen, a recent training session with all our strata managers, learning about our new AGM agendas for next year. So we do have regular fortnightly strata team training sessions with either somebody in-house like myself, or we do get experts from around Strata land to come and present to our team. What else we've been working on? New schemes. So we specialize in new schemes, old schemes, big ones, small ones, tall ones. If it's a strata scheme or a neighborhood or community scheme, it's definitely in our wheelhouse. So we've got some new schemes on board, larger schemes, existing schemes, which is great. So welcome aboard to the NetStrata family, those particular buildings. What else have we been working on? Well, lots of meetings. Part of the strata manager's role is obviously chairing annual general meetings, any other general meeting or strata committee meeting that comes up. So strata managers are busy doing that, as well as arranging roofs. I was going to say arranging works. So that's not us on the roof in the video on the right-hand side, but nonetheless, we would have issued the work order for such jobs. Anyway, enough about us and moving on to Strata Committee training, Paws and proposals, navigating pet ownership in Strata. So what is it that we're talking about this evening? Number one, the precedent and the 2021 legislative changes. So there's a lot that has changed at law in the last couple of years. If you're not across that, this webinar is definitely for you. Jess will walk us through bylaws and pet policies and also talk about property values. It might sound an odd thing to talk about when we're talking about pets, but nonetheless, we'll walk you through our view on that. Assistance and companion animals, what are the rules? NCAT applications, which NCAT stands for New South Wales Civil and Administrative Tribunal. Explain who they are and what they do a little later on in this webinar, and also pet application forms we'll walk you through. Are they still necessary given the recent legislative changes, and I guess how we administer those? All right, so the first topic here, number one, precedent and the 2021 legislation changes. There's a lot to unpack here, but I'm going to start off with walking you through a little bit of a timeline I call it pet bylaw history. So we start off with and I know Strata was around before 1996. However, I don't want to go too far back in time and bore you with a history lesson, but I just sort of want to highlight the key points here. So in 1996, the Strata Schemes Management Act had within it, or within the regulations, 3 pet bylaw options in the model set of bylaws by the New South Wales government. So I guess firstly, let me explain what is a model set of bylaws. Well, a model set of bylaws is basically the government's template set of bylaws that they recommend strata schemes adopt, generally on inception. So when a building is brand new, or even after inception, strata schemes can adopt the model set of bylaws by obviously taking the matter to a general meeting and voting on the necessary changes. But back in the 1996 Act, essentially the 3 options were: option 1, you could have a pet; option 2, you got to have a pet, but you had to ask for approval; and option 3 was you could outright ban pets from strata schemes. So you could have a no pets bylaw, for example. In 2015 was the next major legislative change, and we got the 2015 Strata Schemes Management Act, just short of 20 years later. Basically, the model set of bylaws in this particular case saw one template pet bylaw. So moved away from allowing an outright ban. However, the new model set of bylaws are not retrospectively passed at previous schemes. So when they come in with new model sets of bylaws in the legislation, that doesn't basically kibosh any previous bylaws that you have on your scheme. Your strata scheme or your owner's corporation would basically have to decide whether they wanted to update to the new model set or keep the existing bylaws would just be a given. So as I say, that's completely optional. But it did change the tide, basically, from a scenario where you could ban pets to one that you couldn't unreasonably withhold permission to have a pet. So a bit of a shift there. Then in 2019 came the Cooper case, and I'm going to walk you through this in detail because it's basically changed pet bylaws in Strata land as we know it. So 2019 was the commencement of the Cooper case. 2020 was what we call the Cooper decision. So the courts call out pet ban bylaws, basically marking them as harsh, unconscionable, and oppressive, which is a clause in the current legislation, which we'll refer to in a couple of slides' time. And in 2021, as a result of the Cooper case, changes were made in basically the Strata Schemes Management Act 2015 to allow pet ownership. So it's basically a given that you're allowed a pet unless it's causing an unreasonable interference, which we're certainly explain that throughout this webinar. All right, introduction here. So long have there been battles over pet ownership within strata schemes. So in recent times, several New South Wales Civil and Administrative Tribunal and New South Wales Court of Appeal decisions have held that bylaws banning the keeping of animals are harsh, unconscionable or oppressive, pursuant to Section 139, Clause 1 of the Strata Schemes Management Act 2015. So to better understand the pet owner's landscape moving into the future, it's important to understand the precedent which has been established over the past handful of years, the Cooper decision being the case in the spotlight, which went all the way to the Court of Appeal. So very expensive pet. All right, so the Cooper case, an overview. So the Cooper couple versus the Owners Corporation Strata Plan 58068. So the case began in 2019. So Joanna and Leo Cooper owned a lot in a strata scheme called the Horizon Building in Darlinghurst, 43-storey apartment building in Darlinghurst, Sydney. And basically the bylaw in question was obviously the pet bylaw. I believe it to be the template bylaw, bylaw 16. The strata schemes bylaw prohibited owners or occupiers from keeping animals on their lot or common property. So the Coopers basically brought their schnauzer. So there's a little picture of a schnauzer on the screen there. That's basically the type of dog that they brought in. Now, the contravention then hit. The Coopers kept a miniature schnauzer in their apartment, breaching bylaw 14. And the legal action, basically, the Coopers initiated proceedings in New South Wales Civil and Administrative Tribunal seeking a declaration that the bylaw was invalid. So the Coopers basically argued that the blanket ban on animals contravenes Section 139(1). So they were saying that, hey, look, it's harsh, unconscionable, or oppressive. And basically, the Coopers sought that NCAT, not NCLAT, NCAT, they were seeking that they declare that bylaw 14 was invalid under Section 150 of the Strata Schemes Management Act. So on the 21st of November 2019, senior member GK Burton SC, sitting in the Consumer and Commercial Division, upheld the applicant's claim and declared the bylaw invalid. The Owners Corporation successfully appealed from that decision. So then on the 27th of May, it goes further, 2020, an appeal panel of NCAT set aside the orders made by the senior member. So the applicants sought leave to appeal from the appeal panel to the Court of Appeal on a question of law. So the Coopers then proceeded to take the matter to the Court of Appeal, and on the 12th of October 2020, they won. So the court held that the bylaw in place at the time possesses a blanket prohibition on the keeping of any animal, and in their view, this is considered harsh, unconscionable, or oppressive, again, quoting Section 139(1) of the Act, at least where the restriction could not on any rational view enhance or be needed to preserve the other lot owner's enjoyment of their lots and the scheme common property. So the changes to the law. So further to the Cooper decision, changes have been made to the legislation to deal with the decision. So on the 24th of August 2021, the Strata Schemes Management Amendment Sustainability Infrastructure Act commenced. Now, it's a little bit cheeky that it's called Sustainability Infrastructure. It's basically around how strata schemes vote or pass or make decisions pertaining to environmentally friendly initiatives. And then along came a little pet bylaw change that snuck in that particular bill. So the amendment introduced Section 137B into the Strata Schemes Management Act, which states that a strata scheme can no longer unreasonably prohibit the keeping of a pet on a lot. So big change. So further to the changes in the Act, the Strata Schemes Management Amendment Pets Regulation also commenced at the same time, which sets out the various circumstances which constitute unreasonable interference of another occupant's use and enjoyment of their lot or common property. So effectively, you've got a twofold change here. You've got the change in the actual Act, so the legislation. So here's Section 137B on the screen. And then basically corresponding with this piece of legislation was a regulation which highlighted what unreasonable interference was. So we'll just read a couple of clauses out of this particular change so you can sort of get the theme of what they changed from a legislative point of view. So basically it says this: each of the following has no force or effect to the extent that it would unreasonably prohibit the keeping of an animal on a lot. A bylaw, so there you go, a bylaw can't restrict having an animal. And B, a decision by an owners corporation under a bylaw. So it's taken to be reasonably, sorry, start again. It is taken to be reasonable to keep an animal on a lot unless the keeping of an animal unreasonably interferes with another occupant's use and enjoyment of the occupant's lot or the common property. And here's where they tie in the regulation change. The regulations may specify circumstances in which the keeping of an animal unreasonably interferes with another occupant's use and enjoyment of the occupant's lot or common properties. Now, moving to the regulations. So again, the two speak to each other. Obviously the Bill of Parliament obviously went through and changed the Strata Schemes Management Act, and then the regulations highlight what unreasonable interference is. So this makes sense. So it says for the purposes of the Act, Section 137B, Clause 3, the circumstances in which the keeping of an animal unreasonably interferes with another occupant's use and enjoyment of a lot or the common property are point A, the animal makes a noise. So, noisy dog, noisy cat. Well, cats aren't that noisy, but maybe they are. Dogs are more noisy, like old mate there barking on the screen. Point B, the animal repeatedly runs or chases another occupant. So, clause C highlights, the animal attacks or otherwise menaces another occupant. Clause D, the animal repeatedly causes damage to common property or another lot. E, the animal endangers the health of another occupant, and so on and so forth. You sort of get the theme, right? So the Act says you can have an animal, or the owners corporation can't unreasonably withhold consent, and then the regulations say, well, look, if they're basically a menace, then the owners corporation could then seek that animal is then removed from the site. So previously, as I said, go back to the 96 Act. In most cases, you had to ask for permission, or an owners corporation could outright ban. Now it's a complete flip of that, where they're almost, automatically approved. But if they're a nuisance, you can then, make a case that the animal should be removed, not the owner, the animal. So what does this mean for all? So what's in? Happy, friendly little puppies versus what's out, vicious, dogs or cats or whatnot that, as I said, do something that is noted in that regulation that I just read through. Another change that is actually pretty hot off the press is the Residential Tenancies Amendment Act 2024 was passed in Parliament on the 24th of October this year, introducing key reforms. And there's many reforms, and they're listed on the screen. But the key one we're going to talk about today is making it easier for renters to keep pets. So effectively, a landlord can't unreasonably withhold consent now. So you've got that sort of language at an owners corporation level, and then you've got that language again repeated in the Tenancies Act between the relationship between obviously the tenant or the leaseholder and the landlord or the owner. There's other items in that change, for example, requiring a reason to end the lease, removing no grounds terminations, limiting rent increases to once per year, which I think is the case in many other states, ensuring renters can pay rent by bank transfer or centre pay, or clarifying that extra charges cannot be made as part of search or application process for a rental home. So lots of changes there, but as I said, the highlighted one there is basically making it easier for tenants to obviously get animals. So I'm going to hand over now to my colleague Jess, who's going to walk us through bylaws and pet policies.
I'm just going to jump in. Maybe if we can go back to the last slide, Andrew. There is
Sure.
a question from Adrienne. Can Strata charge an owner to apply to have a pet? Background this year, had to fill in a form and pay an app fee to allow to have my dog. With that
Yep.
one,
Yep. Generally not. So I'm aware that if there are nuisances, for example, you can have bylaws where you've got to basically for want of a better term, evict an animal, or if somebody has breached a bylaw, I've heard of administrative fees associated with that. But actually applying a fee before you have, submitted a pet application, I'm not aware that those bylaws would be necessarily enforceable. But yeah, I do recommend getting advice on that. That's probably more a strata lawyer question, but yeah.
Okay.
Cool.
So this was before moving in as
Before
well.
moving in. Yeah.
Before
Yeah.
moving
I
in.
don't believe you can charge a fee for a pet application before you move in. No. Yeah. All right. So next little section here. So yep, over to you, Jess. So bylaws and pet policies.
Okay, so every scheme should have a keeping of animals pets bylaw, with the exception of commercial or retail schemes. However, that being said, in relation to a commercial or retail schemes, I will give you guys an example that there was this year a strata scheme which did catch on or was caught on fire.
Mm.
Essentially, you had to put in a large insurance claim just to fix that, and finding out along the lines that that was actually caused by a animal by accidentally kicking over a heater in a commercial lot. So although it's mainly for the residentials, just keep in mind that if you do own in a commercial scheme at all, it's possibly something that you should consider as well, just for keeping of animals, because this did happen. Over the years, we have seen a variety of different pet bylaws, some vague, other way, and others way over the top to administer. Legislators have regulated the issue broadly over the past iteration of the Strata Act. So the model bylaws through the generations, as Andrew did briefly mention at the start as well through the PETS bylaw history, pre-1st September 1997. This was where strata schemes recognised that this was having the model bylaws. This was where owners had to seek consent from the owners corporation in order to keep an animal unless they repealed and passed a new bylaw. This still stated that the owners corporations must not unreasonably withhold permission. Moving on, just before the commencement of the new Act on the 30th of November 2016. So schemes registered after the 1st of September 1997. This one was where the options were the three models. So this is where the government allowed where you would either you didn't allow pets, you required approval, or you were allowed to have pets. And then post 30th November 2016, the model bylaws note that either pets are allowed upon notice being given to the owner's corporation or approval must be sought, however, cannot be unreasonably withheld. Since the 2021 amendments, as previously mentioned by Andrew, appropriate worded bylaws should be proposed for owners corporations to consider. So that being into the next point, reviewing your strata schemes bylaw. So consider the process for your pet approval, pet policies, which would go hand in hand and making the processes clearer and highlight unreasonable interference as defined in the regulations. So where your scheme may have an old bylaw, which doesn't actually have the unreasonable interference, bringing us to our next point. Here's an example from Net Strata that we had drafted by a lawyer. We did actually put this on sorry, if you just go next. So we did actually have this on our agendas about 3 years ago, where we were proposing these to our owners to consider if you needed to update your pets bylaw. So for our example bylaw here, we actually had allow pets unless they unreasonably interfered. It also set the guidelines of what animals can be kept. So let's say a goldfish, some birds, dogs, cats. It also requires an owner's corporation to be informed. So this is where we had that pre-application that was mentioned before. We get sent that and we register against your documents. Defines unreasonably interference. So where your old bylaw, where it wouldn't state that, where it might just say must apply for just approval. This one actually defines what unreasonable interference is, as Andrew mentioned, that was in the Act as well. It also requires pet owners to control pets on common property. So this is where owners would need to have a leash on their dogs on common property where they won't be running up to other people's animals. It also sets a cleanliness expectation. So where you might have an owner who has their dog or hasn't washed their dog and their odor is spreading into another's lot and other owners can smell that, it does affect their peace and enjoyment and therefore it sets a cleanliness. It also allows owners corporations rights to remedy a breach and recover costs. Allowing this little last bit on your bylaw also kind of gives consequences to owners that aren't actually following the bylaws for your scheme. It kind of sets a little guideline and also allows you guys to recover costs. For example, if you have a dog owner who isn't picking up after their animal on the common property and leaving their, let's say their feces on there, and let's say you had to hire a cleaner to come in and clean that feces every time, and we know who that owner is, we can try and recover that cost from them through this bylaw too. Examples of a pet policy. So pet policies go kind of hand in hand with your bylaws. So whereas a bylaw might be enough, a pet policy actually allows a bit more of a guideline and also expects expectations for what you may have. So pet policies kind of go hand in hand. It also allows, let's say, your strata manager to kind of understand what guidelines that your committee or your owners corporation set. Some examples include no more than 2 animals per lot. Lot owners approval required for tenants. So this one's a big one. So let's say you are leasing out your apartment block and your property manager has sent in an application for a tenant to have a pet on the lot. We'd want to make sure that that lot owner is well informed of that first, because you might not allow that in your apartment. Application forms to be submitted prior. Your strata committee notification required for all applications, or a strata manager to approve if policy and bylaws adhere to. So this is kind of a good one here as well. This allows to kind of absolve a bit of the stress on your strata committee always being notified, and allowing maybe your strata manager to just already give that approval to that owner that is requesting a pet to be kept on form if you have a pet policy in place. A pet register is also another one that goes hand in hand. If you have a large scheme or a smaller one, a pet register kind of holds the unit, what type of dog or breed, where they're located as well. If you're living in a large scheme and have a building manager, it also assists them as well. For example, on the next one, if there was noise coming in a block area and we didn't know where it was coming from directly, through process of elimination and looking at that pet register, would be able to notify or to see what area that noise is coming from if anyone has a pet there. If noises or bylaw breaches notify the occupant on more than 3 occasions, alternate accommodation off-site to be organised by a pet owner and removed from the building. So this is just kind of bringing back that unreasonable interference and affecting other lot owners and their peace and enjoyment. We would actually be kind of pushing for that accommodation off-site from that pet. Last but not least, a fish aquarium. Dimensions to be noted on this application form for those occupants seeking approve a fish. We do have an example thrown back where somebody did have a really large tank kept in their living room and that leaks. That would then cause some water issues leaking into the unit below, because let's say your living room, it doesn't have that waterproofing where your bathroom kind of does have. So pet policy, good or bad, or is a bylaw enough? So yes, bylaws can be enough. However, as stated just previously, a pet policy can be really, really good. It sets that clear guidelines for new owners and tenants. Once it's confirmed, it also allows managers to approve and streamline processes. Like I said, uplifting that kind of responsibility on your strata committee, and having that clear communication between your strata manager and your strata committee can be good as well. It reduces the questions of what type of dogs will get approved by the committee. A couple cons in that as well, though. However, it is time in setting the policy up. It may create issues where an animal's weight is mentioned, such as, let's say, a 20-kilo dog. And if breeds are specified, it can also be very opinionated as well. So what if an occupant requests something unreasonable? For example, 5 dogs in a 2-bedroom apartment. So this is where that pet policy kind of would come really good place to play. It kind of sets that guideline in there. However, I will note, that being said, it doesn't mean we are denying it. We will deny the application on front. However, we would take that to your strata committee first and allow them to vote. If we can't get a vote there, it would go to a general meeting where all the owners would then have a say in this to whether they would like to keep 5 dogs in somebody's apartment. So number 3, our next point on tonight's agenda, property values. So as we said, a little bit on this as well, property values. So keeping a pet is very highly, really highly, sorry, don't mind me. Really, really highly good. Reason being is everybody usually loves a furry friend. And like we said, you can't be very harsh or unconscionable. So a bylaw in place where a no pets bylaw kind of brings your property value down. So kind of having that pets bylaw already set in place, it allows the scheme to attract owners and tenants alike. This may not directly force prices up, however, adds appeal to your scheme. And also appeal then creates competition for the property for your value property. If you had a corgi and looked at a property with a no pets bylaw, you would just walk out the front door and look somewhere else. So given the aforementioned precedent, however, a no pets bylaw could easily be invalidated as being contravened of section 139, 1 of the Strata Schemes Management Act. So just going to hand this back over to our co-host Andrew Tunks on the next point for him to discuss.
No worries. Thanks, Jess. I'm just replying to a comment on the Q&A, and I thought it's probably not a bad one to throw out to everybody here. We've got a question here from Rosina. We are a strata unit inside an association of townhouses. Do these laws and rules apply to them as well? Really good question. So, strata titled units obviously come in, or lots come in many forms. It could be a townhouse, a villa, a strata unit, or an apartment. And then, of course, on top of that, there is community title, which is basically it could be a block of units is one lot. It could be a scheme where people, buy a block of land and they can build whatever house they like on top of that. That follows many forms. Both the strata and the community legislation, if you have a property that's titled either strata, community, neighbourhood, precinct, etc., then effectively these rules apply to all of those. So when they basically changed the community legislation, it was basically a copy paste of the strata legislation in this respect. So it's got that pet friendly vibe, and effectively, if there was an unreasonable interference, then obviously that owner's corporation or association could then look to have that pet removed. So it does apply in all those circumstances. All right, assistance and companion animals. So moving on, this probably seems like a bit of a no-brainer in terms of allowing these sorts of pets into strata schemes. But there's just a couple of technicalities that we want to bring to your attention. So assistants and companion animals. So they're similar but different. So this is not a dog that brings you your slippers at night. It's one that is actually referred to in Section 9, Clause 2 of the Disability Discrimination Act 1992. So the Strata Act notes that a bylaw cannot restrict the keeping of an assistance animal. So in practice, if someone moves into a scheme and requires an assistance animal, they have every right. Once proof is served that the animal is a registered assistance animal, the owner's corporation cannot cause the animal to be removed. Now, there's all different types here, right? So there might be a guide dog for those who are vision impaired. There might be assistance animals of other nature as well. So we look at them both under the same piece of legislation. So the Strata Act notes Section 139, Clause 5, bylaw cannot prevent keeping of assistance animals. So it says this, a bylaw has no force or effect to the extent to which it purports to prohibit or restrict the keeping on a lot of an assistance animal, as referred to in Section 9 of the Disability Discrimination Act 1992 of the Commonwealth, used by an owner or occupier of the lot as an assistance animal, or the use of an assistance animal for that purpose by a person on a lot or common property. Now, what is a companion animal? Well, it can be a dog, can be a cat, or it can be any other animal that is prescribed by the regulation as a companion animal. So the animal must be registered with the local council and be a companion animal for the owner's mental well-being. The animal may also be a working dog or even a police dog, for example. So we've got a number of examples where we've got police officers within our strata schemes, and obviously, they often, bring their animal home, etc. So they usually go through the same approval process, but it's likely that it would be approved given the type of animal that it is. Moving on here, NCAT applications. Point number 5 of tonight's webinar. So if you're not aware what is NCAT or who is NCAT, it is the New South Wales Civil and Administrative Tribunal. So more or less, this particular tribunal is where most strata disputes go. So rather than, to get a pet evicted running off to Supreme Court or something like that, where it costs you an absolute fortune with lawyers and barristers and whatnot, NCAT is supposed to be a cost-effective, consumer-friendly place to go to see that your dispute gets heard. So there's many levels to this. Generally speaking, there would be mediation prior to some sort of pet dispute where you can talk it out with a mediator to try and come to some sort of agreement between a lot owner and an owner's corporation. And then basically NCAT is basically where you would go to seek an order that either an animal be removed or that a particular owner do a particular thing. All right, so NCAT cases for the keeping of animals are aplenty. I've been to so many I couldn't even count. However, given the Cooper decision and other comparable cases, e.g., the Roden decision, so there's a couple of cases on the screen there, or Yardi versus the Owners Corporation, one would imagine that the keeping of an animal is now a right. However, arguments may ensue should a pet and its owner breach Regulation 36A and cause an unreasonable interference to other occupants within a scheme. So a couple of tips here with regard to NCAT. Obviously, if an animal is within a strata scheme in an owners corporation, a strata committee, or an individual lot owner believes that that pet is causing an unreasonable interference, they might bark at all hours of the night, they might, defecate on common property, they might damage common property. Ultimately, we need some sort of evidence. So, recording, dogs barking at all hours, photos of dogs on common property, misbehaving, all that sort of stuff. Sometimes CCTV cameras come in to play as well, where you can see a dog doing its thing on the common areas, etc., and that can be used obviously as evidence at NCAT, but you do need evidence. So if an owners corporation is seeking an order for the removal of a pet, you have to dot your I's, cross your T's. So effectively, you do need that evidence. So NCAT, key point one. So section 139(1) notes that a bylaw cannot be harsh, unconscionable, or oppressive. So if you did have a bylaw that said no pets in the building, whilst you could still have that bylaw in place, doesn't mean that it's enforceable. So you can pass a bylaw for just about anything. It's whether that bylaw is enforceable or not. Now, obviously, whether a bylaw is enforceable, they do look at precedent, and you've had the Cooper decision as precedent. So effectively, if you had a no pets bylaw these days, I suggest that it would get overturned fairly easily, I would imagine. So this has been obviously the biggest weapon in a pet owner's arsenal when fighting the no pet warriors. So there you go. That's key point number one. Number two, section 157 of the Strata legislation gives NCAT jurisdiction to make an order permitting an applicant, owner, or occupier to keep an animal on the lot or common property if NCAT is satisfied that the owners corporation or OC has unreasonably withheld its approval to the keeping of an animal on the lot or common property, and the bylaws permit the keeping of an animal with owners corporation consent and provide the owners corporation cannot unreasonably withhold consent. The third point that we've got here for you, so disputes in the past, obviously prior to the 2021 legislation changes or the pet-friendly changes, tended to divide into two scenarios. So point number one, where a bylaw outright prohibits pets, so the owners corporation, had no power to give consent, and an aggrieved person considers that harsh, unconscionable, or oppressive, or where the owners corporation withholds consent to a particular pet and an aggrieved person considers that unreasonable. So before the Cooper decision, I did see a mix of applications go to NCAT where they had animals and there was precedent in the building, and I did see them, owners corporations successfully getting them removed, and then I saw a whole bunch of owners or pet owners, should I say, were able to sort of, fight off an owners corporation and keep pets. So I did see both sides of the coin there, but obviously since the Cooper decision, things are a lot clearer, and obviously the 2021 pet legislation. Key point number four here. So future disputes may arise where strata committees insist on denying applications and ignore precedent. So, or as alluded to, where animals interfere unreasonably as referred to in the regulations. So even though that it's quite simple now in terms of the legislation, is very plain English, very easy to read. And, as I mentioned before, generally owners are allowed, or occupants are allowed to have pets. It's only if they are a nuisance under that unreasonable interference clause of the regulations that they could be removed. You still might have owners corporations that say flat out, no, we don't want pets. And that's obviously what NCAT are there to hear both sides of the coin and obviously make a determination. So these matters should be dealt with obviously cautiously and evidence sought prior to any application being constructed. So for those schemes who wish to prohibit animals, obviously the aforementioned precedents should be highlighted to them. So where disputes arise in the future concerning unreasonable interference, it's recommended that applicants clearly demonstrate the breach. So examples of demonstrating the breach, as I said before, we need evidence. So if you're going to remove a cat, a dog, an emu, a rhinoceros, whatever it is in the unit, obviously there's some sort of evidence that needs to be given to NCAT. So there's a few examples here. So statutory declarations provided by other lot owners or occupants or neighbours noting the interference as noted in the regulations. So that might be a stat dec from Sue in Unit 2 who has witnessed, Margaret in Unit 5's animal biting someone in the common foyer or defecating on the, lawn in the common area backyard or something like that. Often we don't always have our iPhones there ready to snap a photo or a video when something happens, but a statutory declaration by that individual, describing the situation would be helpful. Police report. So if there's animal aggression, a police report is certainly advisable. Photo evidence is pretty standard these days of damages to common property and statements by those who observe the damages. So there's just a couple of examples of how you could basically prove breaches of the regulation 36A. All right, just going to change back over to, or hand over rather, to Jess, who's going to talk us through pet request forms and pet registers. So over to you, Jess.
Thanks, Andrew. So pet request forms, pet notification or pet request forms are recommended for owners and occupiers wishing to keep pets, specifying the type and the size of the pet on the form. Despite the 2021 reforms generally approving pets, forms held keeps the owner's corporation informed about pets in the scheme. If a tenant submits a pet application or notification, ensure the property managing agent or owner is listed on the form as well, and obtain written confirmation from the agent that the landlord approves the pet to avoid any potential conflicts with lot owners. So here is an example of a pet request form that NetStrata has. As you can see on here, we have the application details on the lot where we'll have your applicant's names, the strata plan number, the lot owner as well, their phone number and the property manager. You have our pet request details, so what the type of animal is, the breed, the name of the animal and the size of the animal as well. We also have the pre-approval questions. So is the pet currently living in the apartment? Has the pet or the scheme in the strata scheme or other residents previously? So we also have a microchip number. So if your pet is microchipped as well, has it had any behavioral treatment? A couple other ones, we have a checklist as well that attached. So has it got all its shots? We request a photo of the pet as well. Has it got microchip, like I said previously? Is it registered with New South Wales Pet Registry? All these items here we have is something that we can obligate and keep the owners corporations informed. It also acts as something if we do find an incident on clients, we can go back and look through our details to see whose pet it is as we have all the photo and stuff and we can have a look. So just moving on as well from this slide, you'll note on our NetStrata web portal page, we do have a e-form. So on our website, if you go to request forms, you will note and find that we have the pet request form here as well. And this is where you can locate it. Another thing to consider as well, as we did state before, a pet register. So this was where we were talking about it before, where we had a pet policy, where you may need to keep a pet register as well. Where we have a pet register on here, it would keep the type of pet, the breed of the pet, the date that the pet was approved, the method of approval, and the person who was given approval as well. As stating before, having a pet register on site, even in larger schemes, will help your building managers, also your strata managers, just determine which kind of animals, who it belongs to, if there are any incidences that occur.
Thanks, Jess. I'll just butt in there. We've just got a couple of questions that I thought I might answer before we move on. One question here. Hi, Andrew. Please advise whether a tenant can keep more than one pet, e.g. two cats or two dogs, and is there a maximum number? So that's a very good question. In the legislation, there is no mention of a cap. So it doesn't say you can only have one or two or three or four or however many dogs, cats or fish or whatnot. However, it's not uncommon for bylaws to regulate that. It's very common actually to see bylaws or pet policies that say no more than two animals per lot. That is generally a thing. Now, I guess it comes back to, is that unreasonable? So if an owner said, "Hey, I look, I've got a really large townhouse. I've got a really large backyard. I want to have two cats and a dog, and hence breach that two animal rule." I guess that would be a matter for NCAT, but you can have a bylaw that does limit pets. I've also seen bylaws that limit the weight of a pet, but I've never, in my experience, I've never seen them NCAT uphold that. So, for example, you might have a bylaw that says that the dog has to be under 20 kilos, and when the person drafting the bylaw wrote that, they were probably thinking, "Hey, we just want a small sort of pet-friendly animal." But if your pet likes the schmackos, and let's say they're 19 kilos, all of a sudden they're 20.5. And I've seen a case that was very close to that. I think the limit was 25 kilos and the dog was 26 or 27, and they took it all the way to court to fight over a 2 kilo difference. My suggestion was, just ease up on the schmackos at night, and your dog might pass the diet test. But nonetheless, the bylaw was overturned anyway. So you can, like we said before, you can have a bylaw for just about anything. It's whether it's enforceable or not, or whether it's legal or not. And the best way of coming up with a sound structure for a bylaw is to look at legal precedents. They get lawyers to draft the bylaws, and they obviously consider legal precedent and whether something would be enforceable or not. We do have another couple of questions on the Q&A here. So I'll throw to, there's one here under anonymous attendee. Is it considered unreasonable to ban pets from the common garden areas within the building? It may not be unreasonable to ban the pets from common gardens. However, I have seen bylaws which say, you've got to carry your pet when on common property. And obviously, if you're seen to have damaged the area, if it can be proven that it was a particular lot owner's pet, then potentially you could pass on the repair costs to them. I've got another question here. At what point should RSPCA or council be involved in relation to a lot whose dog is excessively barking due to neglect, so being left for more than 8 hours a day at any time, many times a month? I would say to you that you should get the RSPCA or the council involved as soon as possible in cases like that. Often the best course of action is to report it to your strata manager first, and we'll pick up the phone and call the owner. Sometimes, and I had one recently in a building in Redfern where the owner was just unaware that their dog was distressed all day. So they didn't necessarily leave the dog all day, but when they went to work appointments, etc., for a couple of hours, the dog was, on the very large terrace having a bark and disturbing everybody else. They just weren't aware. So as soon as they were made aware, they obviously stepped in and took some action. However, you from time to time you do have pet owners that obviously aren't as responsible as that, and might disagree that their pet is an issue. Again, if you get councils involved at all does come back to that evidence piece. So it is whether or not you've got recordings or photos of that animal doing damage on common property. And again, as Jess said before, the pet register really helps us to tie that into whose animal that might be. So if we see a black bull mastiff or something around the common areas, eating the skirting boards of the common area, something like that, and we can obviously look it up on the register to find out whose dog that may be, and then we can obviously reverse engineer that. All right, I've got another question here. We'll answer that one live. Does keeping a dog under control mean being on a leash? Generally, yes. Generally, yes. It's not explicit in most of the bylaws that I've seen or the legislation, but keeping a dog under control, you would imagine is yes, a lead on common property, or generally either a lead or they're holding the animal. So if it's a smaller dog, some bylaws refer to carrying the animal when on common property, etc. All right. So in closing here, obviously pets in strata schemes are becoming more popular than avocado on toast. So obviously having a clear strategy obviously saves future pain. So we recommend looking at your bylaws, making sure they're consistent with the legislation, the case law, and obviously the 2021 amendments to the strata and community legislation. You can simply review your bylaws by downloading a copy, having a read of them, taking them to a general meeting or a strata committee meeting and talking about it. If there are changes that you do want to make, or you do want a copy of our template bylaw, contact your strata manager. We're more than happy to send it to you. If you've got an older bylaw, perhaps that needs to be updated, more than happy to send that to you. Just so that you know, any changes to the bylaws have to be made at a general meeting, so not a strata committee meeting, at a general meeting. So it could be a general meeting or an annual general meeting. whereby a decision is made by special resolution. So that means more than 75% are in favour or no less than 25% against would be in effect in order to pass that bylaw or change the bylaw. So you could have a potentially an old bylaw, like a no pets bylaw in your strata scheme. To change that, it would be a motion on an agenda of a general meeting, as I said, AGM or general meeting, basically whereby there is a decision to repeal and replace that bylaw with something, I guess, more consistent with the law. So if you'd like some templates, by all means, reach out to us. I'm more than happy to help. And I'll just throw it out there. Questions. So we're coming to the end of our webinar. Are there any questions that you would like us to walk through there? And we've got another one there, Jess. Did you want to read that one out?
Yeah, so I have an owner, or this is from Chris. I have an owner in our lot that leaves his door open to walk his cat. Unfortunately, I'm allergic and there is always cat hair around. What should I be doing? So, in relation to this one here, as we stated before, your cat walking on common property, which is kind of not being held, or if he's just letting it roam around and leaving the cat hair all around, he's not cleaning up after his animal, firstly. So, therefore, we can kind of go back to the owner, give him a call, just let him know that this has been reported, for him to go back and clean the cat hair off the common area on the carpet if that's where it's being left. Another thing is also being noted is if he's not holding his animal, we can let him know that there is the bylaw in place. If your bylaw does depict that you must be holding your animal or keeping your animal under control on common property too. So I would just recommend reaching out to your strata manager or having a read of your bylaws first to be able to see what happens there.
Fantastic. All right. Any other questions there, Jess?
I don't believe so. I think
We've got through them all.
we've got through them all, I believe.
All right.
Yeah,
Well, last 30 seconds, if anyone wants to fire off a last minute question
yeah.
about pets, strata, life, anything, more than more than happy to help. Thank you, everybody, for your attendance at tonight's webinar. Just a last minute little plug for our NetStrata app. So if you want to pull out your phone, scan the QR code and download the app. As I mentioned before, there's all sorts of things on there. So you can get copies of your reports, your ledgers, your financials, your levy notices, meeting minutes, documents of the owners corporation, all sorts of stuff there. So, and there's plenty of app development happening as we speak. So hopefully we'll be rolling out new features to you in the not too distant future. So I don't think we've had any final comments come through there. So I'll just thank Jessica for giving up your evening and talking cats and dogs with me tonight.
Ah, more than welcome to. I'm glad to
No
be
worries.
here.
And thank you everyone so much for your attendance tonight. As I mentioned, there will be a recording. We'll send that through to everybody that has attended or listened tonight. And feel free to pass that on to those who you've not seen log on tonight. Thank you so much.
Thank
See you
you.
next time.
Thank you. See you, everybody.